Thank you. Good afternoon, everyone. It's a real pleasure to be with you this afternoon and to see so many of you here. I was with you yesterday evening when we heard the really inspiring lecture from Baroness Scotland on Magna Carta and the Commonwealth Charter. I'm a Conservative Party member of the House of Lords, and I have been for just over 4 years. And I hope that you've all had a tour of the building and been able to see where it is that I work. I'm a member of the Joint Committee on Human Rights here, a parliamentary committee. I do some work around policing, but the main thing I'm involved with is international freedom of religion or belief. I was really interested, though, when I was giving the briefing pack to have a look at the representatives that are here today. Throughout part of my career, I have lived in Ghana, in Tema, so I think there's some Ghanaians in the room. Hello there, well, Akwaba. And I have also had the privilege to live in Trinidad and Tobago. So, excellent. So it's wonderful. And I'm very pleased to see as well, the place where I go to rest and relax is somewhere called St. Juan's, which is on the island of Jersey. And not Guernsey. I understand Guernsey's also here, Guernsey. So welcome to you. It's really wonderful to see such a breadth of representation from the Commonwealth here. And as we are a little bit more relaxed for time, I've been asked to just fill you in briefly about the work that we do here on international freedom of religion or belief. Now, that sounds a very sort of grand title, but basically it is really about the group of parliamentarians here in the UK. We form ourselves into something called an all-party parliamentary group. And we have groups that focus on particular countries, so you may have received a visit from what we call APPG, that's focusing on your country. Or we have these groups around particular issues, anything from child poverty to the environment, to tennis, to you name it, we have a group. And the parliamentarians who get involved are backbenchers, so they're not members of the government. And they are members of the House of Lords and the House of Commons from all the different parties, and they come together to try and raise the profile of their country or their issue, and often to pressurise our government, so the parliamentarians working together to pressurise the government on the issue that across all the party divisions they feel really, really strongly about. And so we got ourselves together, and because the title of the group now, it's religion or belief, so it includes atheists, people who choose to be atheists, because it's such a long title, our website is called freedomdeclared.org. So I do have a few bits of information here. And the reason why I'm just saying to you about that from the domestic context here is that we got ourselves together and then we were contacted by similar groups from abroad. And the details that you have here under the International Parliamentarians Panel is that in November of last year in Oslo, we managed, with the assistance of the Norwegian government and working in conjunction with the United States Commission on International Religious Freedom, to bring together parliamentarians from across the world, about 30 parliamentarians, who were all concerned about this issue. Freedom of religion or belief is basically the Archbishop of Canterbury has just spoken at lunchtime today to an audience here, just outlining what we mean by that. And what we mean by that is the human right and the fundamental freedom of people to choose their own faith or belief, and how we defend that and how we ensure that people are not pressurised either by their government or by the bullying and intimidation of other communities into not being able to freely worship and freely choose their own religious faith, or choose, which is in some regions of the world becoming more prevalent, people are choosing not to have a faith at all. They choose to be an atheist or a humanist. But we got together as an international parliamentarians panel with MPs from Asia, Sub-Saharan Africa and South America, as well as Europe and the North Atlantic, in Oslo in November. And we are developing that initiative, which is sort of the similar model to like having a parliamentary assembly attached to a government body. But the important thing that we saw develop there for colleagues in other jurisdictions was they had not thought sometimes, or didn't have within their parliament, the model of an all-party group. So what we've actually seen happening is, particularly, say, for instance, parliamentarians in Brazil have decided that's quite a good model. We're going to try and do that in our Parliament and get together across the party lines and from both chambers, if they've got two chambers, to get together around that issue. And we can see, if you were to just even open up the news on your phone at the moment, that people's freedom to choose their own faith or belief is something that has, in the last couple of years, shot up the news agenda. And there are many people who are being persecuted, and nations that are struggling with issues of religious tolerance. And as part of our work, just to conclude, what we are also looking at is that those countries that allow human rights, and particularly allow freedom of religion or belief, tend to have more, women tend to do better in those societies where there's freedom of religion or belief. And also, those countries, there's growing body of evidence that those countries do better economically. And when there's a prosperity there and people, everybody is free to choose their own religion or belief and to choose where to get educated, where to work, and that all employment is open to anybody, regardless of their background. But that's just an outline. Please speak to me afterwards if you are interested. The International Parliamentarians panel is open to new members. As long as people agree with Article 18 of the Universal Declaration on Human Rights, they are welcome to join the panel. So if you or you know of colleagues for whom this is an issue, please come and speak to me afterwards. And it's very important, obviously, for those of us in the Commonwealth. In the Commonwealth Charter in 2013, I think it was the work of the Canadians that very much insisted that freedom of religion or belief was to be part of the Commonwealth Charter. And you will have seen, hopefully through the newscasts, that Prince Charles has been very vocal in this arena on behalf of particularly the communities in Iraq and Syria, the Christian communities and the Yazidis, etc., who have at the moment been suffering a great deal of persecution. So it resonates across a Commonwealth country, and we are joined together through the Charter in having this as one of our fundamental freedoms. But that's an extended introduction to take, to be the beneficiary of more time because of our poor speaker who's got injured on the way in today. But we're delighted you will hear from two speakers this afternoon, and then there'll be a time for question and answers. The first speaker is David Hobbs, who is here from the NATO Parliamentary Assembly. He speaks with one of our wonderful regional accents from the UK, having been born in Yorkshire. And his interest, in addition to his responsibilities, he's chairman of the Euro-Atlantic Foundation, an NGO which provided IT assistance to parliaments in Central and Eastern Europe, developing web-based education models in international relations. And he has written extensively on the political and military implications of the new technology. But he's here really primarily in his capacity of the NATO Parliamentary Assembly to explain more about what that is and how that works with obviously a very significant, I suppose, NGO, still it would be called, of NATO, an alliance of North Atlantic nations. Thank you.
I don't think my colleagues at NATO would appreciate being called an NGO.
No, I don't think they would, but it's not the right term.
Well, thanks very much indeed for that very generous introduction. In view of the substance of the issues that you're discussing, I thought it would be interesting to start, if you like, at first principles and talk a little bit less about, I have to do this, less about the organisation I work for, which is the NATO Parliamentary Assembly, and talk a little bit about NATO itself and the dilemmas, some relatively recent dilemmas that it has faced in dealing with international operations where there's been a conflict between decisions about national sovereignty and human rights and the balance, striking a balance between the two. But I'd like to start by going back to first principles because particularly outside the NATO countries and even inside to some extent these days, after the end of the Cold War, people tend not to think too much about NATO. And when they do, I think they can be forgiven for simply recalling what I would call Cold War stereotypes. And I won't describe them because I think you all know what the Cold War stereotype of NATO would be. But I'd just like to talk a little bit about the NATO treaty itself, because most people aren't aware of what's actually in the treaty, which is a remarkably accessible document. And I think it would surprise most people who've only sort of looked at the headlines and seen what NATO has actually done. But the preamble to the NATO treaty, it's called the Washington Treaty, actually included in that states that the NATO nations are determined to safeguard the freedom, common heritage and civilization of their peoples, founded on the principles of democracy, individual liberty and the rule of law. NATO actually is a values-based alliance, and it puts those values uppermost. And so certainly after the Cold War, you'll hear people say, what's NATO for? And they don't realise they really are asking the right question. NATO is actually an alliance for those values, and it was defined even in the early days of the Cold War in those terms, rather than being an alliance against something. And I think that's one of the reasons that it has endured. I'm not going to go through all the articles, but in the preamble and in Article 1, it says that the NATO treaty is intended to be in full accordance with the purposes and principles of the Charter of the United Nations, and they talk about refraining from the threat or the use of force in a manner which would be inconsistent with those principles. Baroness Berridge mentioned the Canadians. The Canadians were also instrumental in Article 2 of the NATO Treaty, which talks about strengthening free institutions and bringing about a better understanding of the principles upon which those institutions are founded. I would think most people are simply unaware that, that's at the heart of NATO: democratic principles, human rights, rule of law. What they're more familiar with, of course, is, perhaps not by the term, Article 5. Article 5 of NATO is the one why people hear about it. That's collective defence. And it's an extraordinarily important commitment. What it says is that if one NATO member is attacked, then all the NATO members consider that that is an attack upon them. Well, you only make that type of commitment if you feel a very strong bond with the other members of the alliance. So you have to feel that it's a real sense of community. And so those very important principles are upon which it was founded. I'll just dispel another myth on the way. Article 10 says that NATO is open to membership from other European states. And it's funny, over the years you'll see very learned studies, even by former prime ministers, saying that why don't we look at giving membership to Israel or Argentina and all that sort of stuff. Nope, it's open to European new members, that's it. So NATO is actually rather specifically open only to a rather narrow field. I mean, there's still some that aren't in it, but it's not by any stretch of the imagination going global in looking for members. It's, well, there are no others in the North Atlantic NATO area that aren't in. So North America is kind of covered, so US and Canada are there. So it's only open now to new members from the European states unless there's a fragmentation of North America, which we're not looking at. And the other important thing is it operates by consensus. So it isn't, and again there's a stereotype that it's basically a servant of US foreign policy. It's not true. Every single NATO nation has to sign up to a decision, and it's arrived at by consensus, so anybody can block it. That does mean it can be difficult to make a decision, but when you do make it, it tends to be a pretty strong one. Now, it's interesting that as a Cold War organisation, NATO didn't really fire a shot in anger during the Cold War. But what had happened, of course, was that during the Cold War, the organisation had developed terrific models for cooperating amongst militaries. And it had an extraordinarily impressive set of mechanisms for commanding and controlling armed forces. And it was called upon, when the former Yugoslavia was breaking up, actually by the United Nations, to start enforcing things like a UN arms embargo in the Adriatic Sea, a no-fly zone over the former Yugoslavia, and then it was called upon to support UN peacekeepers. And then ultimately it was called in as NATO. And I would have to say, because there was some dissatisfaction with the way the UN was able to perform, that NATO found itself in an actual peacekeeping operation following the Dayton Accords in Bosnia. I won't go into all those operations, but they were UN mandated, and that's very important because with the UN mandate, of course, then there were no questions about the legitimacy of the operation, and nobody did question the legitimacy of the operation. And there were several. NATO also was involved in several operations in Macedonia, helping to disarm warring factions and implement a peace agreement. I'm not going to dwell on that because I thought what I should do is talk about the difficult one. Because in 1998 and 1999, Serbia took action against the ethnic Albanian majority in Kosovo. And I'm sure you will remember at the time there were some appalling things happening, and there were many efforts by the international community in various configurations to try to prevent what was seen as atrocities and ethnic cleansing. That's where the term really, I think, entered European parlance, taking place in Kosovo. And NATO, the NATO nations, the international community sought a UN mandate, and it was blocked. Basically, Russia refused to grant a mandate. It's a member of the Permanent Security Council, and so there was a terrible dilemma what to do. And ultimately, the NATO nations, unable to get a mandate, had to make a decision about whether or not they would intervene to try to prevent these gross violations of human rights in Kosovo. And so they self-mandated, if you like. NATO decided it was going to conduct operations against Serbia to get them to reverse the policies that were taking place. And so there was an operation that ran from the 24th of March to 10th of June 1999, which I'm sure you will remember. Now, interestingly enough, just after the operation started, Russia tried to get a UN Security Council resolution condemning the operation, and only 3 nations voted for it. It was Russia, China and Namibia, and the other 12 members of the Security Council at the time wouldn't do it, but that still didn't constitute a mandate. So NATO had to face this decision: protect human rights or respect national sovereignty. And it's the international law is very vague. It's very difficult to get a clear mandate to do something like that. And since then, there's been a great deal of work done about how you balance responsibility to protect and respect for national sovereignty. International reactions were extremely mixed. Many nations were wholly supportive of what happened. Some were reserved. Interestingly enough, I noticed that some of our Mediterranean partners, because I think many of us thought that NATO would get some brownie points from some of the partners who were sort of sympathetic to the ethnic Muslim minority, but actually some were simply concerned that they perceived that NATO had taken a dislike to the Serbian regime and had simply removed it. And so that came as quite a surprise, I think, some of the people who had really gone in a very complicated situation and made a decision that they thought was based on human rights. Kofi Annan, I think, asked the question at the end about the dilemma that had to be resolved. And he said, if humanitarian intervention is indeed an unacceptable assault on sovereignty, how should we respond to a Rwanda, to a Srebrenica, to gross and systematic violations of human rights that affect every precept of our common humanity? And actually, I should have mentioned that Srebrenica played a big part, I think, in shaping the decision, because there'd been a massacre of 8,000 men and boys in Srebrenica a couple of years previously, and the UN peacekeepers had basically been powerless to prevent that. And there was this terrible dilemma about, could we, in all conscience, stand by and let it happen? And I suppose the fundamental dilemma, you can make all sorts of analogies. If there's a mugging taking place in Brisbane, I'm very sorry about it, but I can't do anything about it. So I don't have to face a decision. If it's happening outside my front door, well, if I have the power to intervene, I must make a conscious decision. I can't just say, well, do nothing. I mean, as a human being, you have to at least decide whether you will or you won't. And it's quite easy, I suppose, if it's you, you'd say, well, I have to do something about it. But supposing I'm the poor guy with the broken arm, well, am I going to ask my daughter to go and intervene? Well, it gets really complicated. And there are all sorts of analogies you can pursue. I would say that Russia, in every single meeting that I've participated in since then, and that was 1998, never shut up about Kosovo and how evil NATO's motives were. And there's a certain irony in the fact that all these arguments which were deployed and rejected utterly by Russia have now been wholeheartedly embraced regarding its totally uncomparable actions in Crimea and Ukraine. Shall I go on a little bit? Yes, do Afghanistan? Yep. Afghanistan, I'm not going to talk about every single NATO operation because there have been lots. And most of them, by the way, are, I would say, uncontroversial because they're ones that people don't often know about. Humanitarian assistance to the United States after Hurricane Katrina, earthquake humanitarian assistance to Pakistan after the dreadful earthquake there. But I suppose the most recent and most recent controversial one was the International Security Assistance Force in Afghanistan. And there again, there are many misperceptions about it. It was UN mandated, so there was a UN mandate for NATO to be there. And in fact, NATO somewhat reluctantly picked up the baton to do that because the United Nations was having considerable difficulty in getting nations to fulfill the responsibilities that it had asked the international community to fulfill. And in 2003, because a couple of NATO nations had taken command and were able to call upon their experience, they said, well, why doesn't NATO do this? And so NATO did. But here we get into the different roles and responsibilities of international organisations. And there are some things which NATO is extraordinarily good at, and there are some things for which it's simply unqualified. NATO doesn't do nation building. NATO is an alliance, and although it has a very substantial political dimension, what it does is it brings to bear military capabilities of its national members. If you are interested in nation building, then you need to go to some of the European Union, which actually has a very substantial budget for doing that type of thing, the United Nations, perhaps other regional organisations. And NATO did some nation building or limited attempts at nation building in Afghanistan because the security environment wasn't sufficiently permissive to let other organisations operate. But if we end up talking about the successes and failures of Afghanistan, I do believe that one ought to talk about the success and failure of the international community in Afghanistan, because what NATO did in Afghanistan in terms of training up the Afghans in order to provide for their own security, and in doing everything that it could to bring the international community on board, it's done, I would say, an extremely impressive job. And if there's a failure, it will be a failure, I think, in terms of economic assistance, in terms of assistance with governance. And for that, I would say the international community as a whole bears a responsibility to assist. Now, what we can say about all that. Each international organisation has its own roles and responsibilities. They unfortunately have non-congruent memberships. So it's very difficult to develop what you would love to have, which is a joined-up, coherent strategy which embraces, economic, legal, law and order, military, the whole package of things that you would like to draw into the equation. And there's a real challenge, I think, in bringing the international organisations that are players, that's UN, EU, regional organisations, NATO, in order to deal with the challenges that we face. And those challenges, of course, are dreadful. We look at Daesh in Syria and Iraq, which poses, I think, one of the most interesting challenges to security, in that I can't think... Is that me?
No, that's fine.
I can't...
It's not the fire. It's not the fire alarm, just
right.
Ignore it.
I can't think of a peacetime situation where our nation's domestic security has been so intertwined with an international security situation, where there's this interplay between the people engaged in Daesh, in Islamic State, if you wish, in Syria and Iraq, and their role back home. And of course, we have the situation where we're having to completely reappraise our relationship, and it's not our NATO, this is our international community relationship with Russia, which we see basically violating international norms of behaviour. And I saw an interesting speech by a Japanese parliamentarian saying, we're interested because we believe in respect for international law. Mm-hmm. That's what's being broken here. It's not sort of just regional security. And I think for strategies to deal with challenges of that nature, there is a need for, I think, people to press their nations to work within the respective international organisations to develop joined-up policy and deliver the strategies which the taxpayer thinks they're getting, but actually isn't. Shall I stop there? Thank you.
Thank you very much, David. I think that's a fascinating introduction to the complexity here. It takes me right back to my university days when I was reading an article by Patrick Duffy on rule of law. And the issue that it highlights is that to rely on your national sovereignty and your borders is a principle of international law. Yeah. And human rights and that treatment is also a principle of international law. Can you rely on the law that says you must respect my nation's boundaries if you are a lawbreaker? Yeah. And you are breaking the law in other respects? And I remember reading that, and his argument was, I don't know if you've read him, was that you cannot rely on the law that says you respect my nation's boundaries if you are breaking the law in relation to the treatment of your own citizens. And I had, a number of years ago, the privilege actually of visiting Srebrenica and seeing firsthand, the memorial and what had happened there, and the way in which it had undermined actually the legitimacy of the UN in terms of the protection, particularly of a Muslim population that was under threat, and seeing how traumatised actually some of the UN peacekeepers had been by being on hand and personally not being able to intervene at that. And they had been, some of them actually gone back to live there and to be part of the community because they felt so much that they had really let down the people of Srebrenica. But another, sorry, certainly, sir.
Can I just ask then, because sorry, doesn't the principle of Magna Carta also apply to states? Like, it's all right to say, do your borders protect you if you're breaking the law? Well, who has determined whether they are breaking the law? That's the principle of Magna Carta, that you should be judged by your peers and you have the right to that trial and that, I guess, court process. Because that takes me back, to the intervention in Iraq, which I didn't see any legal process or court process. I saw a decision of a number of countries to arbitrarily intervene, and I think we can all say now that was a political, strategic and a humanitarian disaster and a complete mistake. Yet it happened. So who in fact was a criminal in that situation?
The real problem is who's the we? Because you say to be judged by your peers. Well,
that's my question to
you.
you.
Absolutely, because you would like to think that the UN would do it. And actually, it's Gareth Evans who did a very good report in the aftermath of Kosovo about the potential way you should assess whether you can trump national sovereignty. And he pointed out, exactly as Baroness Berridge did, if you intervene and get it right, if you intervene and get it wrong, and you could argue the case with Iraq, then you undermine your own credibility. But if you intervene and get it right, as you could argue in Kosovo, you're kind of undermining the UN's credibility, because why did the UN drop the ban? And so the terribly difficult thing, that it's still to be resolved, is when does humanitarian law trump national sovereignty? Can you do absolutely anything that you like to your citizens with impunity or not? And surprisingly, I mean, the only people who are happy in this are the lawyers, because it's not clear. Just briefly, Gareth Evans actually said you need to have just cause, so that you have to have a serious cause that irreparable harm is occurring to human beings. You have to go in with the right intention, which is not like being invited into Afghanistan in 1979 by a puppet regime. Last resort, you have to have tried everything else first. You have to go in, it has to be proportional, fair enough. You have to have reasonable prospects of success. And then you have to have the right authority. And that's the tricky one. Because what happens if you have what we saw, not just the only occasion, when the highest nominal authority, the UN, well, the UN, it's member states. And frankly, member states sometimes act in their own self-interest first.
I think as chair, I'm also going to throw out a few devil's advocate before we move on to Ruth. I'm sitting here and seeing the representatives from Cameroon. Now, of course, we've got the issue happening in northern Nigeria and that's affecting Cameroon and its borders there. So these are really live issues to do with when can one state go into another state to protect its own citizens. And I also had, and I will say it was a privilege, I went to, it's not a Commonwealth country, but I went to the Central African Republic in late September, early October of last year. Now, what do you do in a situation there when you're looking at national sovereignty? And there's a UN peacekeeping force in Central African Republic. If you don't know where it is, and a lot of people don't, it's obviously right in the centre of Africa. It's got Chad in the north, it's got DRC in the south, the Congo, and it's also got, it borders Cameroon, and it's a refugee problem for Cameroon at the moment. And then in the east, it's got the border region of Sudan and South Sudan. But you have a government, an interim government, in control of the capital city and about 20 kilometres outside of that. It's a country the size of France and Belgium put together. But the government isn't actually in charge of the rest of the country. So where does that leave? So just to get your mind on, where does that leave national sovereignty? And yes, the interim government have invited the UN in, there's a UN resolution. But when the government isn't in control of the whole territory, and yet you're also saying, well, this is my national sovereignty, and things are happening to your population in parts of the country that you have no governmental control over at all, and is being run by various militias, and when you have got to, and I'll sum up here, in terms of CAR, so you can say I care passionately about what's happening there, when the security situation is such that Joseph Kony's Lord's Resistance Army is occupying the southeast of the country, but that isn't the main problem. You have got a security situation. So how does international law and national sovereignty play when you are a government, but you haven't got control of your territory? Do we always need the UN resolution to go in and protect a population when the central government isn't actually in control of the territory? But that's just to get you thinking a bit more about the issues that can spring up in this space. But it is my pleasure to introduce to you Ruth Mumbi, who is an NGO activist, and she's a social justice activist and a community organiser who is from Kenya, who's done a lot around women's rights and the women's voices in human rights, and took part as an NGO player in the development of the constitution in Kenya. And we know that that would introduce some very favourable clauses in relation to women's rights. But it's brilliant that she's currently here in the UK studying up in York. And so it's great to welcome you here. So please address us, Ruth.
Thank you very much. And maybe I should make a correction. I'm here in the UK for a fellowship at the University of York. It's a fellowship scheme for human rights defenders who are at risk or have faced risk. But I'm honored here today to be among the distinguished guests that are from diverse backgrounds to talk about my work as a human rights defender. My talk is about protection of individual rights at all levels and the role that human rights defenders play in making sure realization of these rights. As I've been introduced, my talk, I will mostly focus on the work of human rights defenders at the grassroots level in Kenya and share my personal experience as a defender who is based in one of the largest slums in Kenya called Mathare, defending both rights of women and defenders. In December 1988, the United Nations General Assembly passed a resolution commonly known as UN Declaration on Human Rights Defenders that defined a human rights defender as a person or a group of people who individually or with others act to promote or protect human rights. The definition also states that to be a human rights defender, a person can act to address any human right or rights on behalf of individual groups. The declaration basically affirmed that the legitimate role of human rights defenders in the society and the need for the state to protect individuals that carry out human rights work. As such, was when, in 2010, the people of Kenya voted and promulgated a new constitution, which we consider as one of the best and the most progressive constitutions in the world in terms of human rights of individuals, integrity provision for public officers, and devolution of some function of the central government to the regions. There was joy and belief that as a country, we were ushering a new era of respect for human rights, particularly by the ruling class. However, we're still grappling in achieving full enjoyment of various provisions. At the grassroots level, where I come from, where the majority poor resides, the protection of rights of individuals is largely non-existent, as the state, who are the duty bearer, ignores individual rights. This is compounded by lack of necessary skills by the majority of human rights defenders to make demands on the state to respect and protect human rights. However, in areas where human rights defenders have linkages with national networks, meaning that they have access to training and other resources, they are capable of defending and protecting individual rights in a more effective and strategic way. Kenyan Constitution has several clauses that provide for the defense of human rights. These include Article 1 of the Constitution that states that the sovereign power belongs to the people of Kenya. And Article 3 that states that every Kenyan has an obligation to defend and protect the Constitution. Other provisions are in Chapter 4 of the Bill of Rights. Sadly, the above rights are often not realized, partly due to lack of awareness by the rights holders. Human rights defenders have tried to bridge the gap by educating the citizenry about their rights as well as defending individual rights. In many instances, where grassroots human rights defenders have stood to defend rights of individuals, they have seen also their own rights being curtailed and violated with impunity by state and non-state actors. It is more practical to expect that any active human rights defender at the community level has been personally attacked, arrested, arbitrarily, or are faced with criminal charges that are trumped up whenever they uncover malpractices by the state officers. The challenge is that even judicial cover-ups is not uncommon, and the state officers are willing to paint a rosy picture of the state of human rights in Kenya. A case in point is during the recently concluded 21st session of the Universal Periodic Review in 22nd January 2015 in Geneva. The Kenyan government delegation, led by the Attorney General, eloquently stated that the government has been supporting human rights defenders and their work. The Attorney General added that there is no single human rights defender incarcerated in any one of the Kenyan prisons. What the Attorney General failed to point out is the fact that many human rights defenders are facing maliciously trumped up charges and are basically out on bail. These malicious charges are meant to frustrate the fighting spirit of human rights defenders and make them less outspoken. In December 2014 alone, 10 human rights defenders were arrested, beaten, and detained in a police custody before being charged with the crime of engaging in unlawful demonstration. These were peaceful protesters, 2 of whom happened to loudly condemn the police for attacking 6-year-old children with tear gas when they protested the grabbing of the school playfield by a powerful individuals. To further illustrate, I would like to share my own story. On the 28th of February 2011, alongside with other women human rights defenders, I was arrested and charged with inciting public to cause violence. This was because I had participated in a peaceful protest. We spent 2 days in women's prison because we were unable to raise the hefty bail slapped on us. We were asked to pay 120 Kenyan shilling, equivalent of 876 pounds. The amount of money unaffordable to a human rights defender who survived on less than $1 a day. I remember that day, the mother of one of the defenders was present during our court hearing, and she fainted when our bail terms were spelled out. The peaceful protest had been provoked by the alarming number of pregnant women that had died at one maternal clinic in one of the urban poor slums. As concerned women, we were demanding for better services that will limit the maternal death at the facility. This is a basic requirement of our Constitution in the Article 43, subsection 1, that states that every person has a right to the highest attainable standard of health, including reproductive health care. What more, the Millennium Development Goal number 4 and 5 aim to curb child mortality and maternal death, and Kenya was party to the MDGs. I can also share with you an event on the 15th of October 2013. Myself and other civil society organizations organized a peaceful march to petition Parliament on the Kenyan's unjust tax regime that favors the rich elite and big corporations at the expense of ordinary poor Kenyans. We assembled downtown Nairobi at around 10 a.m. The police almost arrived immediately and demanded that we disperse, accusing us of holding an illegal assembly. Armed with the Constitution, we resisted, pointing out that Article 37 of the Constitution guarantees us the right of assembly, demonstration, picketing, and petition. A senior police officer at the Nairobi Central Police Station, in charge of the riot operation, promptly ordered his men to arrest us. The officer used brutal force to arrest us, and out of 8 human rights defenders arrested, I was the only woman. One of the arresting officers sexually molested me by grabbing my private parts before shoving me into a waiting truck full of anti-riot police, who had been brought to disrupt our peaceful protest. Although we were later released with no charges preferred against us, due to the international pressure and local support. To date, the immoral act still disgusts me. I have actually attempted to demand justice for this very incident through the intervention of the East African Law Society in Tanzania that wrote a letter of complaint about the sexual harassment and use of excessive force against me. The then Inspector General of Police, called Mr. David Kimayo, acknowledged receiving of the letter. But to date, no further communication, investigation, apology, nor any form of action has been taken against the police in question. These are not the only stories that I can share with you of the dream of human rights that has not been realized. I recall on the 17th day of February, approximately at around 10 a.m., 7 members of the Highway Self-Help Group, a community-based organization where I come from, were arrested by the police. The group, the community organization, was carrying out the Self-Help Group, a community-based organization that carries out economic empowerment program of the youth through garbage collection, were attending a routine group meeting to discuss their internal issues. They were holding their meeting at Kiamaiko. This is an informal settlement in Huruma, in a low-income neighborhood around Nairobi. The group was confronted by the police officer from a nearby police station who demanded a permit for the meeting, despite there being no such a requirement in the Kenyan law. Article 36 of the Constitution guarantees us the right of assembly and association. Sarah Ashina, a grassroots woman human rights defender from the Highway Self-Help Group, courageously told the police that there is, according to her knowledge, there is no such a law that exists. One of the police officers, feeling provoked by Ashina's statement, slapped her on her face, telling her to shut up her big mouth. They then arrested her and the rest of the members of her group. During the arrest, the police officers, who were all men, used excessive force on her. Ms. Sarah Ashina, who was at the time 8 months pregnant, was mercilessly hit and pushed to the ground by the police. Other human rights defenders arrested by her were physically assaulted by the police. Apart from physical manhandling, they were also verbally abused with profane, obscene insults as they dragged them to the police station. At the police station, they were not immediately booked in. Instead, one of the arresting officers scribbled their names on a scrap paper, contrary to the laid down standard of police regulation. This irregularity was just a mere tool to intimidate the defenders in order to give bribe in exchange for their freedom. And since they were not willing to give out bribe, they were detained in the police cells. The following day, the defenders were taken to court and charged. Ms. Sarah was charged with assault, obstructing, and resisting arrest. She denied the charges, and she was released on 10,000 Kenyan shillings, equivalent of 73 pounds, cash bail. The 5 male human rights defenders who were also in the meeting were charged with drunkenness. The latter, who all lacked legal representation, opted to compromise and plead guilty to avoid being remanded. They were fined 400 Kenyan shilling, equivalent of 3 pounds. However, the national human rights coalitions and institutions such as National Coalition for Human Rights Defenders, Independent Police Oversight Authority, Independent Medical Legal Unit, Rights Protection Program, Bunge la Mwananchi, Coalition of Constitutional Implementation, Bunge la Wamama, to name but a few, have been providing avenues for defense and protection of human rights defenders. At the national level, limitation of these organizations' good work come from the state crackdown on them. The law limiting foreign funding, smear campaigns against civil society organizations as agents of foreign agenda, and other overwhelming cases of judicial harassment has been quite a great challenge and has thus limited the organization's ability to meet all the needs of Kenyan human rights defenders. As a way forward, there is a need for stakeholders to start capacity building workshop and in-depth training targeting grassroots human rights defenders working in remote areas so that they can be linked to other human rights defenders and networks worldwide, as these will help in having an empowered population that can in turn defend and promote individual rights. In conclusion, I appreciate the learning opportunity and the exposure granted to me by the Center for Applied Human Rights at the University of York, where I'm participating at the Protective Fellowship for Human Rights Defenders at Risk. And with great humility, I thank the UK government for granting me a visa. For this, I've been able to network and acquire new skills. But at the same time, I will humbly request the UK government to issue visas to other human rights defenders at risk with ease in order to support them in their work in difficult circumstances across the world. I'd like to acknowledge the efforts of international non-governmental organizations who have been working closely with us in making sure that we are able to overcome all these challenges. As human rights defenders, we feel more protected and empowered because of their support. The Peace Brigade International, Kenyan chapter, volunteers have been working with us and giving us protective accompaniment. That has made us feel less vulnerable, and with gratitude to frontline defenders for always being there to bail out human rights defenders who are judicially harassed. Appreciation too goes to Amnesty International, who have created a grassroots platform for us to engage with the police in order to create a better understanding between the police and the community. Thank you.
Thank you, Ruth, and thank you so much for what clearly is a very brave stance that you've taken in Kenya. And thank you so much for coming to the UK, and I'm sure that your contribution at York, it really stands out for us, that many of us are sitting here in countries where speaking out, particularly when you're in public office like a parliamentarian, is quite protected, but we recognise that a lot of people take serious risks in relation to that. So thank you so much for coming to address us. I just wanted to say, before we open it up to formal Q&A, that when I was hearing Ruth speak, and we're talking about the Magna Carta here, this is kind of Magna Carta level 3, in that what we've had reflected here in this story is to do with the rule of law. Yes, everybody should be tried in accordance with the law, but Ruth's statements about trumped-up charges and the use of the law of the land, if you don't have an independent judiciary in order to protect people like Ruth, and that is what the Magna Carta was the beginning of the development of, that there's a role for the state and there is a role for the citizen, and it's partly, as parliamentarians sitting here, your role to protect that space in which human rights defenders and other organisations and charities and NGOs can work in your communities, and ensure that the judiciary is not part of your government or be able to be used like that. Now, before I sort of appear to be a UK person here, we have these issues today. You know, I was just looking at one of the screens. We've been dealing with a child abuse scandal that's been going on for decades here. And we have had to appoint now a judge from New Zealand in order to ensure that we have an independent person who has no connection with the ministers and the government of the day to ensure that the inquiry is independent. So we have similar issues. So thank you so much, Ruth. Now, any questions in relation to David or in relation to what Ruth has said?